A fiery hearing tonight, turning combative and contemptuous.
Do you want to go there, Attorney General?
Attorney General Pam Bondi sparring with lawmakers over the Jeffrey Epstein files.
And I told you about that, Attorney General, before you started.
You don't tell me.
Yeah, I did tell you because we saw what you did in the Senate.
Bondi pressed on whether there could be other prosecutions.
We have pending investigations in our office.
Potentially a reference to Democrats the president asked the DOJ to investigate. In contrast to the department's acknowledgement last year, they did not uncover evidence to warrant charging anyone new. Bondi accusing Democrats of using the Epstein case as a deflection.
The murder rate, as I said, has plummeted to a 125-year low. Thanks to Donald Trump. That's what we should be focused on.
And in her remarks, adding this to Epstein abuse survivors.
I am deeply sorry for what any victim has been through, especially as a result of that monster.
Bondi acknowledging the files did not redact private information of some survivors, some sitting right behind her.
Raise your hands if you have still not been able to meet with this Department of Justice.
What's happening, guys? Welcome back to Dr. John Podcast. Judge Matthew Brann issued a 130-page ruling dismantling Pam Bondi's DOJ staffing scheme, warning that unconstitutional appointments could allow dangerous criminals to walk free. The same pattern has now been found by federal judges in at least 5 states, New York, Virginia, California, and Nevada, independently reaching the same conclusion about illegal prosecutor appointments. The scale of what's actually at stake here is genuinely staggering when you stop and think about it. We're not talking about some obscure bureaucratic reshuffle that nobody outside Washington cares about. We're talking about who actually gets to decide whether someone accused of a serious federal crime faces prosecution at all, in office after office, across state after state.
It was a hearing that was combative right from the very start.
You can let her filibuster all day long, but not on our watch. Not on our time. No way. And I told you about that, Attorney General, before you started.
You don't tell me.
Yeah, I did tell you because we saw what you did in the Senate.
A hearing with Attorney General Pam Bondi that got so heated, one Democratic member left the hearing room.
Didn't ask Merrick Garland anything about Epstein, not once. When he was
weak sauce.
Also, I want the record to reflect that, with this anti-Semitic culture right now, she voted against a resolution condemning.
Oh,
is
Jewish.
I just want to be clear.
Do you want to go there, Attorney General? Are you serious? Talking about anti-Semitism to a woman who lost her grandfather in the Holocaust.
Bondi challenged by Republican Tom Massey over the Department of Justice redactions in the file, including Leslie Wexner, founder of Victoria's Secret.
Within 40 minutes, Wexner's name was added back.
Within 40 minutes of me catching you red-handed.
If the very people making those decisions never had legal authority to hold the job in the first place, every single case they touched becomes vulnerable to challenge. That's the kind of stakes hiding underneath this story. Every investigation they opened, every indictment they brought, every plea deal they negotiated, all of it potentially tainted by the fundamental illegality of their appointment. And when you understand that this pattern has repeated itself across 5 separate states, you begin to see that this isn't just a series of unfortunate mistakes. This is a coordinated strategy, a deliberate attempt to bypass the constitutional confirmation process by installing loyalists in powerful federal positions without ever going through the Senate.
There was one redaction out of over 4,700. This guy has Trump derangement syndrome.
Congresswoman Pramila Jayapal asking Epstein survivors in the audience to stand and offering Bondi the opportunity to apologize to them.
Will you turn to them now and apologize for what your Department of Justice has put them through?
I'm not going to get in the gutter for her theatrics.
Afterwards, several of those survivors sitting down with NBC's Hallie Jackson.
Show me your hands if you were satisfied with what you heard from the Attorney General today. Nobody. There wasn't even an adult in the room that could apologize for the damage done to children and girls.
Saying they just want accountability.
We've heard several times our government say, we're moving on from this, and that just enrages me.
And despite all the theatrics, Bondi did reveal more could come in the Epstein saga, telling Congressman Chip Roy that there are still pending investigations in the case, but she did not say who they are focused on or when they might be resolved.
Before we go further, it's important to separate real news from fiction. A lot of the wildest clips circulating online claim that Bondi collapsed in open court in some dramatic courtroom scene, but that's not what actually happened. Bondi did not literally collapse anywhere, but what actually happened is genuinely stunning on its own, no exaggeration needed. Judge Brand's ruling completely dismantled Bondi's attempt to install 3 hand-picked lawyers, Jordan Fox, Philip Lampareel, and Arif Fonteo, as a kind of makeshift leadership team running the U.S. Attorney's Office after Trump's original pick. Alina Habba got disqualified for staying in the job illegally past her allowed time limit. Brand didn't just disagree with the arrangement. He tore it apart.
You apologized to the survivors in your opening statement for what they went through at the hands of Jeffrey Epstein. Will you turn to them now and apologize for what your Department of Justice has put them through with the absolutely unacceptable release of the Epstein files and their information?
Congresswoman, you sat before, Merrick Garland sat in this chair twice.
Attorney General Bondi.
No, can I finish my answer?
No, I'm going to reclaim my time because I asked you a specific question that I would like you to answer, which is, will you turn to the survivors? This is not about anybody that came before you. It is about you taking responsibility for your Department of Justice and the harm that it has done to the survivors who are standing right behind you and are waiting for you to turn to them and apologize for what your Department of Justice has done.
Members get to ask the questions, the witness gets to answer in the way they want to answer. The Attorney General can
that's
respond.
not accurate, Mr. Chairman.
Because she doesn't like the answer.
Time.
So,
Mr. Chairman,
why
I have asked
didn't she ask Merrick Garland this?
Calling the Justice Department's defense of it a rhetorical smokescreen. He wrote that the government had assembled what he called a convoluted patchwork of statutory cross-references specifically designed to craft a leadership structure that could do everything a real U.S. attorney could do without technically being one. That's not a minor technical objection. That's a federal judge directly accusing the Justice Department of engineering a workaround specifically to avoid the Senate confirmation process the Constitution requires. The history of this fight over the New Jersey U.S. Attorney's Office makes the audacity of the administration's position even clearer. Trump's original pick for the job was Alina Habba, his own former personal lawyer, someone who had represented him in various legal matters and who he clearly trusted to run a major federal prosecutor's office. Under federal law, someone can serve as an interim unconfirmed U.S. attorney for a limited period, 120 days.
I'm reclaiming my time, and when I reclaim my time,
Mr. Chairman, the gentlelady has reclaimed her time.
I'm not going to get in the gutter for her theatrics.
How many of Epstein's co-conspirators have you indicted? How many perpetrators are you even investigating?
You showed it. I find it.
How many have you indicted?
Excuse me. I'm going to answer the question.
Answer my question.
No, I'm going to answer the question the way I want to answer the question.
No,
Your
you're
theatrics
answer the
are
question
ridiculous.
the way I asked it.
Chairman Jordan, I'm not going to get in the gutter with these people, but I'm going to answer the question.
How many have you indicted?
Again, the time belongs to
reclaiming my time.
The time belongs.
I think it's very interesting.
Reclaiming my time.
I think it's very interesting.
You can reclaim your time.
He talks about they indicted. The president said they indicted him twice.
Mr. Chairman, please stop the clock and restore his time.
Okay, here we go with these
Committee will get in order.
theatrics.
The time belongs to the gentleman from New York. We will give you a few more seconds. We will do that. But when you ask a question, the witness gets to answer. You may not like the answer, but she gets to answer.
The question was, how many of Epstein's...
They don't like the answer, Chairman,
my time.
because it's honest. So he asked a 4-minute question.
Restore 45 seconds to Mr. Nadler, please, Mr. Chairman.
Answer.
You can let her filibuster all day long, but not on our watch.
Specifically to give the Senate time to actually confirm a permanent pick. Habba stayed well past that limit. Judge Brand ruled all the way back last summer that her continued service was illegal. A federal appeals court agreed unanimously, and Habba was forced out of the role in December. It's worth understanding just how unusual it is for an appeals court panel to unanimously back this kind of ruling. The three-judge panel that upheld Brand's original decision included judges appointed by both a Republican and a Democratic president, all reaching the exact same conclusion. That's not a partisan split decision. That's a broad bipartisan judicial consensus that the original appointment simply didn't meet basic constitutional requirements. So here's where it gets genuinely audacious. Instead of following the normal process, having Trump nominate someone new and letting the Senate actually vote, Attorney General Bondi tried something different. She split the U.S. Attorney's authority across 3 separate DOJ lawyers, essentially creating a 3-person committee to quietly do the job of one Senate-confirmed U.S. Attorney without ever actually filling that position through the proper constitutional channel. Brand saw right through it. And here's a line from his ruling that genuinely cuts to the heart of the entire pattern. He wrote that through its statements and actions, the administration has made clear that it cares far more about who is running the office than whether it is running at all. Sit with that for a second. A federal judge appointed originally by President Obama, writing in an official court opinion, said this administration would apparently rather leave a major federal prosecutor's office in legal limbo than accept anyone the Senate didn't personally handpick and rubber stamp through proper channels. Brand went even further, tying this specific fight to much bigger constitutional principles. He wrote that 1 year into this administration, it is plain that President Trump and his top aides have chafed at the limits on their power set forth by law and the Constitution. That's about as direct a rebuke as you'll ever see a sitting federal judge issue against a presidential administration in writing. And it becomes part of the permanent public record, something that historians and legal scholars will reference for years to come. The Appointments Clause of the Constitution is not some obscure technicality that can be waved away. The framers specifically built Senate confirmation into the Constitution as a check on presidential power, a way to make sure important federal positions couldn't simply be filled by whoever a president personally favored without any outside review at all. Bypassing that requirement isn't a technicality. It's circumventing one of the specific structural safeguards the Constitution built in from the very beginning, precisely to prevent exactly this kind of unilateral executive action. Now, here's where the story gets even bigger, because this genuinely isn't just about New Jersey. The same basic pattern, installing unconfirmed hand-picked prosecutors and trying to keep them in place indefinitely, has played out in at least 4 other states as well. New York, Virginia, California, and Nevada have all seen federal judges disqualify Trump-appointed U.S. attorneys for essentially identical reasons: exceeding legal time limits, avoiding Senate confirmation, using creative personnel maneuvers that courts kept finding improper. In California, the disqualified prosecutor was Billy, and in Nevada, it was Sigo Chata. Both installed through similar workaround appointments that judges in their respective districts eventually ruled improper. That's genuinely remarkable when you step back and look at it as a whole. 5 separate federal court systems spanning coast to coast, involving completely different judges with completely different backgrounds, all independently arriving at the same fundamental conclusion about how this administration has been trying to staff its prosecutor offices. And here's a detail that connects this entire pattern to something even more consequential. In Virginia, a judge ruled that prosecutor Lindsay Holligan had been unlawfully appointed, and as a direct result, actual criminal indictments she brought against former FBI Director James Comey and New York Attorney General Letitia James had to be dismissed entirely. Think about that. Real charges against real high-profile defendants thrown out specifically because the prosecutor who brought them never had legal authority to hold that job in the first place. That's not some abstract theoretical warning about future cases. That's an actual, real-world consequence that already happened. It's worth pausing on the political weight of those specific dismissals, because Comey and James weren't random defendants. They were 2 of Trump's most prominent political adversaries: the former FBI director who oversaw investigations touching Trump directly, and the New York Attorney General who successfully pursued the civil fraud case against his businesses. Watching charges against exactly those 2 figures collapse, not because of any factual weakness in the underlying case, but because of a basic constitutional defect in how the prosecutor herself got appointed, is exactly the kind of outcome that should give anyone pause about how these appointment shortcuts actually play out in practice. Here's something else worth understanding, because it shows just how far this pattern actually extends. In some instances, when courts tried to exercise their own legal authority to appoint temporary U.S. attorneys to fill these vacancies properly, following an actual legal process available to them, the Justice Department responded by immediately firing those judicially appointed prosecutors. That's an extraordinary escalation. It's not just resisting Senate confirmation. It's actively undermining the court's own attempts to fix the problem through legitimate means. This is the kind of behavior that suggests the administration views the judicial branch not as a co-equal partner in governance, but as an obstacle to be circumvented. When courts try to exercise their constitutional authority to ensure that federal offices are filled properly, the Justice Department simply fires the people the courts appointed and tries again with their own preferred candidates. That's not how the system is supposed to work. That's a deliberate strategy of resistance. There's also something worth noting about Haba's own conduct in that original New Jersey role, because it adds real weight to why judges have been so alarmed by this entire pattern. While serving in a role courts eventually ruled she never had legal authority to hold, Haba used her position to open investigations into New Jersey's Democratic governor and attorney general, and brought charges against a Democratic mayor and a sitting member of Congress. Whether or not those specific actions had merit on their own, the fact that they were carried out by someone whose very authority to hold the office was legally disputed the entire time adds a genuinely troubling layer to this whole situation. When an unconfirmed prosecutor starts targeting political opponents, and it later turns out she never legally held the office in the first place, it raises serious questions about the legitimacy of everything she did. And Bondi and Haba's response to all of this tells you something important too. Rather than acknowledging the legal problems these rulings kept identifying, Haba publicly called Brand's ruling ridiculous and vowed on social media that judges may continue to try and stop President Trump from carrying out what the American people voted for, but we will not be deterred. That's not a legal argument. That's a political statement, framing a constitutional ruling about Senate confirmation requirements as some kind of partisan obstruction, rather than engaging with the actual substantive legal problems Brand identified in exhaustive 130-page detail. So here's the honest, complicated truth sitting underneath all the dramatized headlines. Bondi didn't collapse in open court because that's not how any of this actually played out. But a federal judge did issue one of the most scathing, and this fits into a documented pattern spanning at least 5 separate states. That's a real substantive story, and it's honestly more alarming than any single dramatic courtroom scene could ever be. The pattern is unmistakable. The Justice Department is trying to install loyalist prosecutors without Senate confirmation, courts keep ruling those appointments illegal, and the Justice Department keeps trying again with different creative workarounds. This isn't a mistake. This isn't confusion about the law. This is a deliberate strategy, and judges are pushing back with increasing force. Judge Brand's ruling is genuinely one of the most significant legal rebukes Bondi's Justice Department has faced. 130 pages of detailed legal analysis, warning explicitly that dangerous criminals could walk free, calling the administration's legal defense a rhetorical smokescreen. That's about as serious as judicial language gets. And it came from a judge who'd already ruled against this exact same office once before, meaning this was his second time reaching the same fundamental conclusion about the same underlying problem. The first time, he ruled that Haba's appointment was illegal. The appeals court agreed. The second time, he ruled that Bondi's workaround was illegal too, and he did it with language that left no doubt about his view of the administration's conduct. This isn't a case of a judge making a close call on a difficult legal question. This is a judge saying the administration is transparently trying to evade the Constitution. The implications of this pattern, extending across 5 separate states, cannot be overstated. Each new ruling adds to a documented permanent record of constitutional violations. Each dismissed prosecution, like the Comey and James cases, represents a real concrete cost. But the administration also hasn't stopped attempting these same maneuvers, which suggests they're betting on appeals or simply running out the clock, hoping enough time passes that the practical damage outweighs any eventual legal correction. There's a real strategic calculation happening here, worth understanding, because it explains why the administration keeps pursuing the same approach despite repeated losses. Every day these hand-picked prosecutors remain in their positions, even under legal challenge, is another day they can continue directing investigations, making charging decisions, and shaping how federal law enforcement actually operates in that specific district. Even a temporary, ultimately overturned appointment still produces real lasting effects during the period it remains in place, which means losing eventually in court doesn't necessarily mean losing entirely in practice. That calculation only works, though, as long as courts keep allowing stays pending appeal, which is exactly what happened here. Brand caused his own ruling specifically because of what he called the novelty of the legal questions involved, giving the government time to appeal before the three-person leadership team actually loses their authority. That stay is itself a genuinely important detail because it means the practical impact of this ruling right now today is actually quite limited. The real consequences depend entirely on what happens next at the appellate level, which could still take months to resolve. Watch closely for what happens on appeal with Brand's ruling specifically, since he stayed his own decision pending that appeal, meaning the three-person leadership team technically remains in place for now, operating at what Brand explicitly called their own risk. Watch for whether additional states join this growing list of disqualification rulings, because if the pattern keeps spreading, it becomes increasingly difficult for the Justice Department to argue these are isolated, one-off legal disputes. The Justice Department's response to these rulings, firing judicially appointed prosecutors, publicly dismissing rulings as ridiculous, insisting judges won't deter them, suggests this pattern isn't accidental or the result of confusion about the law. It looks like a deliberate strategy, repeated across multiple states, specifically designed to keep loyalist prosecutors in place, regardless of what courts actually rule, treating adverse legal rulings as obstacles to road around, rather than binding decisions to actually comply with. That's an attitude that has serious implications for the rule of law. When the executive branch decides it can simply ignore court rulings it disagrees with, or work around them through creative personnel maneuvers, the entire system of checks and balances starts to break down. And that's exactly what judges across 5 different states have been trying to prevent. The connection to a much longer-running debate about executive power more broadly is also worth noting. This same basic tension, a president wanting maximum flexibility to appoint loyalists versus a constitutional structure specifically designed to require outside review through Senate confirmation, isn't unique to this administration. It's a recurring fault line in American governance that resurfaces periodically regardless of which party holds the White House. What makes this particular episode notable is the sheer scale and consistency of the pattern. 5 separate states, multiple different judges, all reaching essentially the same conclusion within a relatively short window of time. That kind of consistency across multiple separate legal systems is exactly the sort of thing that turns a single embarrassing ruling into genuine evidence of a coordinated national strategy. In the short term, it's genuinely hard to see how the Justice Department benefits from repeatedly losing this exact same legal argument in state after state. Every new ruling adds to a documented permanent record of constitutional violations, and every dismissed prosecution like the Comey and James cases represents a real concrete cost. But the administration also hasn't stopped attempting these same maneuvers, which suggests they're betting on appeals or simply running out the clock, hoping enough time passes that the practical damage outweighs any eventual legal correction. Watch closely for whether more criminal cases end up getting dismissed the way the Comey and James prosecutions did, because that's where this abstract constitutional fight turns into immediate real-world consequences for actual defendants and actual prosecutions. It's also worth watching whether Congress ever gets more directly involved in this fight, since the core issue driving nearly all of these rulings is the Senate's confirmation power specifically being sidestepped. Some of these nominations, including Haba's original one, stalled specifically because sitting senators actively opposed them. That means part of this story isn't just about judges pushing back. It's about the Senate's own constitutional role being circumvented, too. And whether that chamber ever takes more assertive action to actually defend that authority going forward remains a genuinely open question. So did fed-up judges pull some kind of nuclear move that made Bondi literally collapse in open court, the way that dramatic headline suggests? No, not literally. And that specific dramatized image doesn't reflect anything that actually happened in any courtroom. But did a federal judge issue a genuinely devastating 130-page ruling that dismantled one of Bondi's central prosecutor strategies, warned of mass criminal case dismissals, and fits into a documented pattern spanning 5 separate states? Yeah, absolutely. That part is completely real, and it's honestly a far more serious, more consequential story than any single dramatic courtroom collapse could ever capture. It's worth sitting with why the real version of the story matters so much more than the dramatized one, because the distinction genuinely says something about how political information spreads today. A fictional collapse generates instant visceral engagement. A 130-page constitutional ruling warning about the Appointments Clause and separation of powers requires more patience to actually understand, even though it carries far greater real-world weight. That's exactly why stories like this one tend to get buried underneath more sensational, invented alternatives, even when the true version is objectively more significant. Every time a court forces the executive branch to actually follow the constitutional appointment process rather than simply installing whoever it prefers, that's the system working exactly the way it's designed to work. It's slow. It's not dramatic in the way a viral clip wants it to be. But 5 separate federal courts independently reaching the same conclusion over the same underlying issue is genuinely one of the clearer examples of judicial checks and balances functioning in real time that you're likely to see in any single news crime cycle. The fight over who actually gets to run federal prosecutor offices is far from finished. The pending appeal of Brand's ruling, the ongoing fights playing out in 4 other states, and the very real possibility that more criminal cases could collapse the way Comey's and James's already did. All of this means this story is far from a closed chapter. Between the sealed status of Smith's final report on the classified documents case, ongoing questions about whether that material could ever become public, and the standing hush-money conviction that remains part of Trump's legal record, this story about his own recorded words is far from a closed chapter. Next time, we're digging into exactly what happens if this pattern reaches the Supreme Court, and whether the justices ultimately side with the judges who've been drawing the same constitutional line or with an administration determined to keep testing it.